Welcome to Find the Money, the podcast that breaks down and brings clarity to the financial issues faced by family lawyers, business owners, and divorcing spouses. I'm Jason Soman. I'm a divorce forensic accountant and business valuation analyst here in South Florida. On today's podcast, we're going to talk about intangible assets, intellectual property, patents, trademarks, and we have a special guest today. We have Derek Fahey of the Plus IP firm. It's a law firm specializing in intellectual property. Derek and I connected, and I saw there's a lot of information that he has that's going to be useful for people going through a divorce, especially nowadays. More and more people's net worths are tied up in intellectual property, things that have maybe not tangible value, but have value from the sense that they enable you to have certain contract rights or the ability to do certain things. So welcome, Derek, to the podcast. Thank you for coming to join us.
Thank you. Thank you for having me. Appreciate it.
So tell us a little bit about your practice. What are the types of assets that you're dealing with your types of clients?
Yeah, so great question. So intellectual property is just like any other type of property, house or a car. It just is the right or the concept of if you have unique stuff or if you create unique stuff, you should own the rights to it. So whether it's a brand name or a book or a unique idea or software, you actually have rights to it. And just like a house or a car, you can actually, it has value. So you can actually get a loan against it. You can borrow against it. You can receive money based upon that asset. So even though it's an intangible asset because it's not a physical thing, you can, just like a car or a house, you can actually sell it. And our practice is focused exclusively on actually creating the asset from your thoughts and ideas and then monetizing it. And then obviously, if you have to enforce it, again, to make sure that other people aren't using it, that's what we do.
Yeah, because I imagine that having all the paperwork in place is the difference between having an idea that someone else could take or steal versus having something that you could potentially sell one day or make a lot of money from.
Yeah, exactly. Funny you say that. A lot of times people will come to me and say that they've had this creative idea and they've been using it for a long period of time, and they now want to try to get an asset from it or create an asset by getting a patent or trying to obtain a patent. But if you've been selling things for over a year, then you actually can't get a patent on it because the patent laws basically prevent you from doing that. So more than anything else, whenever you're dealing with intellectual property, you need to know what to do, but you also need to know what not to do because certain things can have really bad effects on your rights. You can really could affect your rights on things.
Yeah, and I mean, one of the reasons why I thought there was so much synergies between the experience that you have as well as what the audience is more divorce focused is because these are assets that generate income. These are assets that maybe there's not a lot of money put into it, but they are extremely valuable. There may be a hidden asset somewhere, not just in the form of something that's undisclosed, but maybe something that's undervalued. If someone has a patent to use a certain technology, there may be value in it, although there may not be income being derived from it now, or there may not be a high value on that patent right now. Maybe you could just tell us a little bit about like what is a patent and how's that different from like a trademark or a copyright, kind of like IP 101.
Oh yeah, let's do it. Okay, so patents protect different inventions or designs. So a utility patent protects the functional features of a design or of an invention. So for example, how a software works, how a device that you have in your phone works, the functionality of those features are protected with, it's called utility patents. And also design patents protect, really protect like an actual design, like the look and feel of a product. And generally speaking, the person who creates the asset, the inventor, actually owns the rights to the invention. So if you have a husband and a wife and the inventor is the wife, and she creates an idea and gets a patent for it, it's going to be in her name only. But I don't know much about family law, but I do know that if an asset's created during the marriage, it's a marital asset and can be shared. So if there's an asset in a spouse, one of the spouse's names, that asset probably is considered a marital asset. And I have many clients that actually will have patents out there and get offers for licensing agreements based upon those assets. So it may not be earning money from a licensing agreement, and a licensing agreement essentially is an agreement to pay the owner of the asset money in exchange for a right or license to use it. You may not have a license now, but they may be working on a deal, or they may be in the future when the technology gets to the point where it makes sense to actually monetize it. It could be valuable. So it's something to think about. If there's any patents that someone may or may not have, they need to be thinking about, hey, when was this created? When was the asset created? Do I have any rights to it? And if it was a marital asset, you may have rights to it. Mm-hmm.
Oh yeah, I mean, I imagine that I could just see situations in a divorce where everything's good in the marriage. Someone's telling them, "Oh, I'm creating this patent. It's going to be worth big bucks someday down the road." And I could just see in the divorce situation, all of a sudden the tune starts changing.
Oh yeah, yeah. You're right. It happens all the time. I have recently had a case with like copyright. So copyrights protect books, artwork, poems, poetry, any sort of material like a photograph that's fixed at tangible medium. So issue was with the works that were created for these like manuscripts and memoirs for actually the male spouse. And there was a dispute over who owns the rights to that actual manuscript because it was created during the marriage. Technically, be the husband, but who would own it? What ended after, if there's a divorce, that's considered a marital asset. So it happens a lot more than you think, and it may not be monetized now, but it may be not monetized in the future. And to your point, right? People always change your story to their benefit. I'm sure you've seen that a lot, given your background.
Mm-hmm. Absolutely. So how are these valued? Because I'm just thinking like I'm working with a couple getting divorced, and there's a patent, no one disputes it, but it's not really being used right now. Like there's no income from it. Like I wouldn't even know like how to justify a value to a patent without seeing some type of income or seeing other patents being traded with similar characteristics for certain prices. I mean, how are they valued, or what are some things where there's evidence of value? Like,
Yeah.
because I'm trying to figure out, well, is this worth something, and if so, how much?
Yeah, I mean, you hit the nail on the head. The best way to look at it is, past revenues. How much are they actually making from the license? And then evaluating based upon that license, how much is it worth moving forward? That's the number one way to do it. If there's no current revenue stream just being generated from a license, then you can actually look at other factors as well. There are experts like you that do this for a living, and many times this also comes up in when you have patents and you have people trying to raise capital. They will go to an expert and say, "Hey, here's my medtech device. I think we're trying to raise capital. Here's the market. Here's where we're positioned. We think we can break into the market and capture 1% of 1% of the market. We think it's worth X. What do you think?" And the CPA slash evaluation expert will use their formulas and evaluate it. It's very common in the venture capital context to do that with pre-revenue. I mean, think about all the IPOs that or think about all the startups that that get these crazy billion-dollar evaluations, or even just say lower numbers like multi-million-dollar evaluations without any revenue. Where is that coming from, right? It's just the thought about what it could be generating in the future.
Yeah, so I imagine that because like I think of it, because I've had discussions with people about like non-compete agreements, and I
Mm-hmm.
almost feel like a patent is similar in the respect that it's like it's not like do you also have to consider when you're analyzing a patent and what the value is how likely are you going to be able to defend it, because the like a non-compete, for example, it's only as good as you as what you could enforce it, so like do you have to analyze like if someone steals this idea, how likely am I to prevail on this patent dispute, or something like that? I mean, maybe I'm not using the right language because I don't know the industry well enough, but is there
You did
any?
a you did a good job. You did a good job. Um, so there's you know there's broad patents. When I say there's broad patents, I mean there's a patent. Well, first off, a patent is a legal document that prevents other people from making, using, selling, import, or exporting a device or a method for a limited amount of time. It's a limited monopoly. In the case of utility patent, you have a limited monopoly to prevent everybody from doing what the patent is claiming for 20 years. So that limited monopoly could be a really broad or a very great limited monopoly because it's a very broad patent. The scope is very broad. Or you could have like a very, very narrow limited monopoly. In other words, it's not that strong because it's only limited to this one little thing and you can get around it by doing something else. And that's one of the things that a patent attorney would do is they would evaluate whether or not other products are infringing on a particular patent. Another thing that patent attorneys do quite often is, hey, we have this patent. Is it valid? It may not even be valid. One of the things that you see a lot of is competitors going to patent attorneys and saying, hey, I see this, my competitor has this patent. I'd like to compete in the marketplace here. Can I do that without getting sued? And that's called, they ask for freedom to operate opinions. Hey, can I operate in this area without getting sued? And that's part of the game. Is we do that a lot in the patent world. Is we have clients, whether it's a person who's looking to evaluate to see how broad it is or how narrow it is, and then helping the person determine can they operate, can they operate without infringing. In the context of evaluation, quite honestly, I think it depends on which way you want to argue. Quite honestly, there's obviously going to be two sides to every argument. And but what about you? For your experience, do you see that quite often in evaluations on intellectual property assets?
Not really with intellectual property assets. I haven't been in that situation, but I see it with other types of assets. I feel like I'm holding a cap for a 20-ounce bottle of soda. Like I don't know, maybe it has 20 ridges on it. Like I don't know. Is there a patent to have 20 ridges on this soda cap? If I'm doing a divorce and the spouse has a patent for one that has 22 ridges on it, you know what I mean? It's like, is that a valuable asset? I don't know. You know what
Yeah.
I mean? Like, I feel like there's probably a need potentially in valuation disputes involving patents, almost like the need for an expert witness to opine on like the validity, because
Mm-hmm.
because just because I have this patent for a soda cap with 20 ridges on it doesn't mean that someone's not going to produce that, right? Because you have to, in order to enforce the patent, you have to come up with a lawsuit and you have to win, right? It's not
Mm-hmm.
like you just create a patent and people just stop competing with you, right?
Yeah.
There's some type of active enforcement that's required, and I imagine it's very subjective. I mean, it sounds
Yeah.
like it seems like
Howard,
it could be a very complicated area.
well, I don't know I don't think it's maybe it's more complex than the average, thing, but it can be complex. But in the evaluation world, if a lot of times people are using intellectual property assets to to generate capital to sell. When they go to sell a business, that's one of the things that they're selling is this intellectual property asset. So what are you going to be selling? You're going to be selling contracts, your agreements that you may have. You're going to be selling physical assets, and you're going to be selling intellectual property assets. For example, if you own a software company and you have an intellectual property asset like a patent on something that is related to what you're selling, that patent actually may be tied not only to in the case of this divorce dispute, that patent may actually be the reason why there's a licensing agreement. It's just not maybe not tied into it. Maybe it just doesn't state that the owner of the patent or the spouse may say, oh, this is worth nothing, when actually that intellectual property asset's the whole reason why they have this whole business kind of operating. So, another thing to think about is like software, the owner of the software code owns the software. So if let's say you have a company and you have like the software code, and the wife takes the company and the husband says, okay, you can have the company. And then after the divorce is done, the husband says, well, actually, I actually own the software code. You can't use the software code because I own the copyrights to the software code. So now you're going to start paying me money for the use of that software code. Okay. That's some things that that may happen actually, is
Yeah, I
because
imagine, because you got to really identify what's the asset. Is the asset the shares in the company, or is the asset the intellectual property? How does it work with, like, do companies own trademarks, copyrights, and patents, or do individuals, or both?
both really. In fact, earlier before we got on the podcast, before we started recording, we started talking about how can you tell who owns it? You can actually go and look up this recorded on the United States Patent and Trademark Office. You can look up and looks for a person's name to see if they own any intellectual property assets. So that's the thing that we do. I just did a video a couple days ago on how to find the owner. If you like a product, the brand that says it has a patent, how can you go find to see what that patent is? Maybe you want to start selling it. Maybe you say, hey, it's a great idea, I want to do the same thing, but they say they have a patent. What do I do? You need to see if they actually do have a patent. You can actually figure that out, and I did a blog post on that. But same thing with divorces. You can actually go on the United States Patent and Trademark Office or the Copyright Office and see, do they own a trademark? Who owns the rights to that trademark? Sometimes individuals will actually own the IP rights that are associated with the business. So they will actually just own the IP rights, or a holding company could own the IP rights, whether it's a patent or a trademark or a copyright. And the business I lost you.
I'm here. I don't know. You froze. I
Oh,
didn't. So you said, I'll cut this part out, but you said something. It's decoupled between the person and the company. The person owns it.
yeah. Both, either the person or the company can own the intellectual property rights. And
Yes, I imagine that's a big thing in divorce also, because you don't know whether you're valuing the company. Does the company actually own it? I mean, there's definitely some valuation considerations to be had.
yeah. What is this? What's this? I'm going to switch this around a little bit. What's the stickiest, if you can tell me, what's like one of the stickiest things you've dealt with in the last like 6 months where you're like, oh man, this is messy.
I think what it comes down to is, I think messy situations are when you start mixing like family law stuff and corporate disputes, like a husband and wife are business partners and also getting divorced. Then there's like, okay, well, are you dealing with the civil lawsuit, or are you dealing with a family lawsuit? I mean, you're kind of dealing with both, right?
Mm-hmm.
Um, those could be sticky. I mean, a lot of times it's just like, what's difficult is people with very messy financial situations. that may be very expensive to fix, but not necessarily having the money to fix it.
Mm-hmm.
So it's like kind of dealing with like, well, is the juice worth the squeeze? I mean, that's something that's very common in divorce situations where
Mm-hmm.
it's like, is this accurate enough, or like what's the cost of true precision? If I
Mm-hmm.
let's say that someone owns a business and the business records are a mess, like, and I'm estimating their income's 100,000 a year. Like, is it worth $10,000 for me to get that number completely accurate or not?
Yeah.
I think that's a big one in divorce. But I think some of the complexities also arise with respect to these complicated assets. People own more and more complicated things nowadays that the value is just less tangible and less easy to understand. If someone owns a carried interest in a private equity firm, that's a complicated asset to really understand and value. Someone owns a patent; those things are kind of complicated to value, and I mean they have a lot of value. I mean, maybe you could tell me about some stories of like some of what are your clients' patents and copyrights and things like that are worth. And when I say what they're worth, not how did you value them for any purpose, but like what did they sell them for? Like what are people actually paying for these things?
Yeah. So it depends, right? I mean, small businesses, a lot smaller. I have a tech ad tech software firm that got private equity funding for upwards of 500 million. Um, it just depends. A lot of times the intellectual property is a big factor. They want to see something. Sometimes it's more the contracts. It's more the contracts that are worth it. The fact that they have an agreement with NBC or CBS or some other large manufacturer, some other business that's a large business. And it just really depends. I find a lot of the times, if there's strong patents, you're going to get a higher valuation. Or if there's a strong, if you can value, whether it's a licensing fee, you get a much higher valuation. And sometimes it's optics. Sometimes it's optics, that raises the buzz. And then therefore, after you raise the buzz, then, it increases the valuation. The one that I said 500 million, that's one of the larger ones that my clients have had, but that's based upon on patents, on software patents. So yeah, I got another question for you.
Yeah.
Going back to like in the husband wife slash business partner situation, what is one thing that they could have done that would be helpful in order to not go through an entire mess? What would you think is like, hey, listen, obviously nobody wants to get a divorce, right? But what are some things that you'd recommend to like family law attorneys that they could advise their clients that, either in a prenup or for the next marriage, what would you, if you're going to go into business or have a business with your spouse, what are some things that you can do? Obviously, you never want to get a divorce. What's some things that you should be doing and thinking about to avoid those issues?
Yeah. I mean, I'd say the first is to just not have, any extramarital affairs with any people that work at that business. I mean, that's
That's
probably a
step one.
starter.
That's step one.
That's step one. I think a lot has to do with like information. I think with a lot of disputes, marital, shareholder, things like that, it's just like transparency of information and making sure that people who want information could get information. Like a lot of times what happens with a family dispute and also shareholder dispute is, like the one person's on the out, the other person's on the inside. So there's one person that has knowledge and control of the finances, and then there's another person who uh, should be getting some benefit from that, but doesn't have that full transparency. So I think a lot of that's a lot to do with it. It has to do with trust, transparency, things like that. I'd say those are like the big things. I think that things get messy with litigation in general as it relates to documents and discovery and things like that. So I think being cooperative, being transparent, all those things I think are huge value adds.
How did you actually get into eval? I mean, I know you're a CPA by background. You have more, three letter acronyms in the back of your name that I can probably even pronounce. But how did you get into doing evaluations for business divorces or for divorces?
So I just kind of I worked at a CPA firm. I just interned and I got wrapped up with the group. The group that did what I do now. They needed help, and I helped them. I did a good job. They wanted more help. It just
Mm-hmm.
kind of happened organically. I mean, I went back to school to become a CPA after I graduated from my 4 year degree. So it just kind of happened organically in terms of how I got into forensics and business valuation. And I don't think I'd want to do one without the other. I think that regular business valuation could be kind of repetitive, commoditized, maybe a little boring sometimes. Um, and forensic accounting, it's very factual. It's very based on what actually happened, the numbers, so on and so forth. But I kind of like mixing the two elements because valuation, there's a lot of subjectivities to it. Accounting, there's not. So it's like a mix of more of a way to be analytical within the accounting realm,
Mm-hmm.
as opposed to just kind of recording what happened, things like that.
Yeah.
It's a little more exciting for me.
You love what you do?
I do. I do. I
Cool.
really, I think it takes a certain type of individual to enjoy working on divorce cases. But one person's passion is another thing that people hate doing. I mean, there's a lot of accountants that would never step foot in a divorce situation. So, there's opportunity, I think, also doing things that other people don't want to do.
Yeah. Do you think that you mentioned that you like if you did only business divorces, so to speak, right? A business valuations, you find it boring or monotonous. Do you think the same thing about family law, kind of forensics? You find that would be more of a because would get boring, or you're like, no, that's it for me. What do you think?
Yeah, I mean, I think that I think that the valuation issues in the context of a family law case tend to be bigger. They tend to be more challenging, more complicated. There's more at stake. A lot of forensic accounting sometimes in a divorce is just like, okay, this cash account was this balance on this date. To me, that's requires less skill and experience than saying, okay, this business is worth this much on this date. So I think I just enjoy the challenge of it.
Mm-hmm.
I think that like determining what the value of a cash account is as of a certain date is not that you don't need a forensic expert CPA to do that, but you do when the issues are bigger and more complicated. So I'd say, it's not to say that I don't enjoy just doing a regular evaluation or I don't enjoy doing a normal forensic accounting. It's just my niche is kind of where those two worlds collide because I enjoy kind of using both sides of the brain and doing some digging that really makes a difference in terms of the value.
Mm-hmm.
And I mean, when you're dealing with evaluation, a lot of times companies are worth several millions of dollars. So it's just I find it very interesting where you could analyze the accounting and that could be the basis for making a value change.
Mm-hmm. A couple of things you said really kind of hit a chord for me. I love what I do, and I definitely, you said it's not for everybody. Being a patent attorney is not for everybody. I have friends who are like, how the heck do you stare at these things all day long? But it's a challenge to be able to figure out what the inventor thinks is inventive, and then use your knowledge of the law to think, okay, well, how can I get this? And it starts to become high stakes because now they're pumping money into this investment, and the entire investment is based upon acquiring this one piece of intellectual property to lock out the competition. That's what they're going to seek investment based upon. So we get to have all these little wins, like when you get the patent, it's like, all right, yes, because now they have this asset that they can raise capital, they can license, they can exclude others, they can try to build a product around this patent, or they can get a patent to build around the product. But sometimes we get a patent and then they build the product around the patent, because it just depends on what it is. And it's really fun, and it's competitive because you're constantly trying to reach a goal to an end, and it's creating an asset, which is super cool, as opposed to litigation where you're just constantly, you're picking up the phone and you're thinking like, the person on the other line is thinking, how can I screw this guy over or get around this guy? Or like, how can I outmaneuver this guy? That's not kind of what you're thinking. You're thinking about how to create an asset, and like what space is still available in the area, and how can you add value, which is fun for me. That's kind of like what I like. And it gets down to like the nitty gritty details. And, it's not for everybody, but like staring at those things and like figuring it out, I really enjoy. And I think that a lot of people in our firm we try to find people that have the same mentality, So I think we have a lot of similarities with each other.
Yeah, I imagine it's almost like, I don't know if it's like estate planning, but it's almost like, you get the patent, you do everything right, but then it's the test comes when it gets challenged, when it gets that's when you find out if Derek really dotted his I's and crossed his T's,
Yep.
Like, do you feel like every time you finish a client or finish a project, it's like, okay, it's like a ticking time bomb until sometime in the future, all of Derek's work is going to be tested, like it's going to go in front of a court and hold up, you know what I mean?
Yeah.
I'm sure there's a lot of that in your business also, right?
Of course, every time a patent is litigated, the validity of the patent is challenged. So it's basically, I'm in a lawsuit, okay, the patent's invalid, right? That's what happens. But even before that happens when someone comes to me, they ask me, hey, can I get a patent on this particular device? I developed this new unique device, what I think is cool and I can make money off of. Can I get a patent? So before we even are applying, I'm telling them yes or no based upon the law and what we find. So even before that, sometimes I give it an opinion, and 4 or 5 months down the line, I'm waiting to find out whether or not my analysis is correct. And a lot of times it's a yes or no. It's, so it can be stressful, but that's part of the challenge. And that makes the win so much more fun. That's what makes you work so much harder and fight so much and want to advocate so much more for your clients, because you know how important it is to them. And you also know that their wins are your wins, and a rising tide raises all ships, so to speak. So it's part of the fun. That's why I like it.
I assume it's almost like the government, when they approve and deny patents, it's almost like going to a judge, right? Like, you can't guarantee someone that it will be accepted. You could only kind of estimate based on your prior experience, based on case law. I mean, is that how it works when you're trying to figure out the chances of something kind of going through? Or
yes, kind of close. So how it works is, before you file a patent when you file a patent application, once you file the application, everything that existed before you filed, like all the inventions that were before you filed your application, will affect your ability to get a patent. So for example, if you invent a unique pen, all the pens that existed before you filed your application are going to affect your ability to get a patent. So if the exact same pen was invented before, your application for the patent will get rejected. That makes sense, right? Like, you're not going to get a patent if it already existed before, right? That's not how that works. You're getting a patent on an idea that's new and unique and non-obvious, right? So typically, when you file an application, eventually a patent examiner, which is a patent attorney at the United States Patent and Trademark Office, will actually do their own search, and they'll look for everything that they could find. They've tried to basically find everything that's out there that could affect your ability to get a patent on that particular device. And if they find the exact device, they'll reject it and say, nope, look, there's this other pen that was existing before you filed, so we're going to reject this. So what we do as patent attorneys is we go look for stuff to see if you can get a patent. And then we tell the client, it's called a patent search. We tell the client, hey, based upon this patent search, here's our patentability opinion. Can you get a patent or not on the invention? And then it gives our analysis and our recommendations. And sometimes we say it's not patentable. A lot of times we say it's not patentable. And, there's other ways to protect it. But sometimes we say it is. And then we file the application. And then when you go back and forth with the patent office, you basically try to decide, okay, how broad of an invention do I get? Do I get a very narrow scope, or do I get a broad scope where I can actually stop other people from using and selling the invention from a large area? So it's fun. You're literally creating an asset. So I love what I do, so I could probably talk about it all day. I don't monopolize the conversation.
Is there like, can the patent office ever let in two patents that are similar, I assume, and or they could deny wrongfully, right? Like, how do you appeal that? Or if, let's say, I own a patent and someone gets a patent very similar to me, what do? I sue that company or individual that created that patent?
Yeah.
Or
So
do I sue the government, or how does that work?
happens all the time, man. The searching for other patents is an art. So there's over 11 million patents right now in the U.S. alone. So, sometimes the searcher doesn't find everything that's out there. And there's times when you have two patents that one of them should not have been allowed. And then you have to kind of figure out who should have the rights to it. Generally speaking, it's the person who filed first should have the rights. That's kind of how that works. But, it happens. They make mistakes. You can appeal the decision of a patent examiner. You can actually appeal to what's called the Trademark Trial and Appeal Board. That's like the patent office's boss. And if you don't like their decision, you can actually appeal to the Federal Circuit Court of Appeals, or you can appeal to a district court in the state of Florida or wherever you're located. So if you don't like the decision, it's not the be all and end all, but the appealing a decision from the patent examiner, you face a high, it's a high bar.
Absolutely. It sounds all very interesting. I also heard about people, like, if there's something that is top secret, they may not want to file a patent, right? Because they may not want, if you have some invention and you don't want people like I mentioned before, the soda cap, right? You don't want someone like knocking it off and changing it very slightly. You may not want to file a patent, right? Because it's all out there.
Oh yeah. Great example is Coca-Cola. It's called a trade secret. So, a patent lasts 20 years. A trade secret lasts as long as it's kept secret. So if you can actually, if you're able to if people can keep things a secret, manufacturing processes, special recipes, those are kept secret and called a trade secret. In fact, Coca-Cola, I don't think any one person knows all of the ingredients and how to make it. It's made in different parts in different areas. And then, one person does one element, one person does another element that ultimately makes the actual thing. And that's how they operate. That's why it's kept a secret for so long. Good example is data. Right now, the training data, a lot of times people, or, the data is an asset. It's an asset. And you can't protect that. You can't protect the actual data with trademark law. You can't protect it with patent law. What you have to do is protect it with agreements to keep that data secret. So if somebody were to take that data and take it someplace else to use it against you or to make money off of it, you can get money damages from that as for misappropriation of trade secrets. That data is super valuable. I mean, that's why Facebook's a multi-billion-dollar company. It's the data that it generates.
So do you ever have people come in your office and you're like, hey, it sounds great, but I think you should just keep it a secret instead of doing a filing?
Yeah, a lot of times. So sometimes we do this analysis. We do an analysis for them. We'll do a patent search, and we'll see that it's not patentable. And we'll say, hey, listen, this is not patentable. If we file for a patent, everybody's going to know what's out there, because the policy behind patent law is you have to disclose how to make and use the invention to get a patent. And then after the limited monopoly time, everybody will know what it is. That's kind of like the policy disclosure in exchange for a monopoly, so that the world can benefit from your idea, right? But if you think you're not going to be able to get a patent, and it's an important idea to keep secret, then let's keep it secret so that nobody, if we can't keep it secret, let's keep it secret. Maybe it's a certain formulation or a method, and maybe it's a certain way to actually create a formulation or a certain way to do certain things. You can actually keep that secret formulation secret and keep that secret for as as an asset for as long as it's basically kept secret. So absolutely, we do that.
Yeah, it's I think after this conversation, because like, whenever we start a new case, we search on Sunbiz, we look at,
Yeah,
what businesses does this person own, what real estate. We'll look through the county appraiser. But now after this conversation, I think I'm going to start looking at the trademark search and look at the patent office and just try to see if do these people own anything that might be an
yeah,
invention that's just not showing up elsewhere.
yeah,
So I think it's a good idea to add potentially, especially nowadays, a patent search or a trademark search to the person's name, see what we could find. I mean, there may be some interesting stuff you could dig up from there,
yeah.
especially since everything's public.
Yeah, absolutely. In fact, I may do like a training video so you can check it out. It's fairly simple. You can search the first name, the last name. You can see if they're recorded. Typically, companies will actually record the ownership interest in a particular asset, and you can see the security interest. You can see, if a bank owns a security interest. A lot of times, banks or different funds will actually record their security interest in the intellectual property asset, like a patent or a trademark or copyright, so that when you're going to sell a business, they can look to see, hey, do we have all the releases for this security interest? Does anybody else own rights to it? Is there mortgage on that? You're supposed to be recorded. You can go online and look at you can go and look for Taylor Swift's songs. She is the owner, or her business is the owner of all the intellectual properties, all the songs, and you can see that. So same thing with a husband or a wife. You can go and look that up.
Yeah, I find what you do very interesting. It's something that you don't really think about, but it's like you can't live your everyday life without it being exposed to this stuff in real time. I mean, I'm sure the platform we're recording this podcast has a ton of intellectual property and the way that the buttons are kind of.
Yeah, everything.
I'm sure this is exposed. I'm sure you probably can't even go to the grocery store without like looking at like the tune of the jingle when they scan something. Like that's probably like some type of proprietary something or another.
Yeah, people say, oh yeah, I don't know I don't think I know anything about intellectual property. And I think about that, and every single thing that you do, like the chair you sit on, your computer, when you go make that Keurig cup of coffee, there's so much intellectual property everywhere, because it's the idea of if you create cool, unique stuff, you should own the rights to that. That's the whole general concept. You create something that's cool and unique, you should own the rights to it. And it's everywhere. I mean, everywhere. It's really cool.
As a society, it gets us further along because you're incentivized to create cool stuff because you'll benefit financially from it.
Yeah, that is the policy and the reason for like intellectual property, like the patent office. That's the reason why that exists, right? You disclose your invention, and then in exchange for this disclosure, you get a limited monopoly for a period of time, and then afterwards, everybody can use it, right? So that's why you see generic drugs after 20 years. Start seeing generic drugs come out, like a great example, one that's recent, is Viagra. I think the patents are all running out, so you're starting to see all these different generics come out because now the world is benefiting off of that. Same thing with like Botox. Botox originally actually was a drug for migraines, and because they were able to patent the method of using this particular composition for decreasing wrinkles, you got a whole bunch of other intellectual property rights, and I believe those are expiring soon. I believe, but it's powerful. I mean, pharmaceutical companies, Amazon, Facebook, they all are based upon intellectual property rights.
I imagine this is a highly technical field. Like you probably have to be familiar with all these types of, I don't know, electronics. Like you must need to know like all these very technical pieces of products and services and
Mm-hmm.
businesses that your clients are coming to you with. Because like, I don't know, it seems like the difference between a certain curve on a bottle could end up being something
Yeah,
that's
yeah,
valuable.
yeah. That's one of the fun things about my job. So I get to learn so much awesome stuff all the time. That's every single day I'm learning something new, which is unbelievable. But yeah, to be a patent attorney, you have to have an engineering background. I have an engineering background as an engineer for 5 years before going to law school. But essentially, you may not have to know, you don't really know have to everything, but you have to know where to look. You have to know the basics about, what's a capacitor for electrical engineering. You have to know some basics. And just like with you, you learn to think about things in a certain way, to analyze problems in a certain way, like mathematics. That's what mathematics is all about, right? It teaches you how to problem solve. It's here's a problem. You have all these rules, create the solution. And as a patent attorney, it's really cool because there's a lot of rules, but there's also a lot of creativity involved with writing, and that's kind of really fun to experience that.
Yeah. So, where could the listeners reach out to you if they want to learn more, want to do a search, want to potentially get intellectual property patented or trademarked?
Yeah, sure. You can find me on YouTube if you Google Derek Fahey. I think it's ESQ, Derek Fahey ESQ, on YouTube. www.plusfirm.com, plusfirm.com is my website, and then Derek Fahey PA is my Instagram handle. I think we're on TikTok as well. So if you just Google Derek Fahey patent attorney, I should pop up somewhere.
All right, great. I think this has been an informative episode. I know you're a very passionate guy. We could probably go really deep in some of these
Yeah,
topics
man.
for a while, but I think that the listeners got a lot of value. I think they kind of know a little bit more about stuff that they maybe didn't know about before. So I think it's going to be very useful. I think I'm going to add some more investigative techniques into my repertoire based on our discussion, and look forward to having you back. If you'd like to learn more about me and my firm, please visit us at www.divorceforensicaccountant.com. Thank you again, Derek.
Hey, man. Thanks for having me. Appreciate it.
Take care.